Welcome all to this webinar organized by Lydian on international data transfers. My name is Bastiaan Bruinooms. I am leading at Lydian the data protection and privacy practice, and I will be presenting today this webinar together with my colleague and counsel in the firm, Olivia Sant'Antonio, and with my associate, Pauline Hellemans, who will also do a part of the presentation today. Let me maybe first give you a couple of practical tips and issues. First of all, the presentation that we will be using today during this webinar can be downloaded at the right-hand side of your screen under handouts. That's the first issue. Secondly, you will receive, after having attended the entire webinar today, you will receive a certificate from GoToWebinar. So make sure that you stay until the end of the webinar. Third point is that during the webinar, in order to verify attendance and so on, we will have two poll questions. There will be one poll question after the first part, the introductory part, and then another poll question after the second part. And you will have some time to respond to these poll questions. So please make sure that you respond to these poll questions. Then last point, as regards questions, if there is time for questions, for us to answer questions, we will certainly take the time at the end of this webinar. If you have any questions during the webinar, please make use of the chat function in GoToWebinar, which you also find on the right-hand side of your screen in the little panel. We will try to respond to the questions that come in during the webinar at the end of the webinar, or if there is no more time, or if it's a very specific question that requires some more research, for example, then we will individually respond to you by email after the webinar has finished. So let's get started right away with the topic. I think that after Schrems II decision of the European Court of Justice, international transfers have been on the agenda and have been a priority for many organizations, both small and large organizations. And this is, of course, the reason why we wanted to organize this webinar, to give you a bit an update on where do we stand with international transfers of personal data. What will be the structure of the webinar? Well, we have devised this webinar in three parts and then a question and answer session. During the first part, which I will do, is I will give you an introduction on the topic of data transfers, and I will more specifically focus on when do we speak of a transfer, and specifically an international transfer of personal data. That will be the introduction, and I will give you the different criterions that have been established so far by the European Data Protection Board. During the second part, my colleague and counsel, Olivia Sant'Antonio, will speak about the different legal mechanisms that exist for transferring data out of the European Economic Area. And she will discuss, for example, adequate decisions, the new standard contractual clauses, when can you rely on derogations, and so on. And then in the last part, my colleague and associate Pauline Hellemans will speak about the so-called transfer impact assessments, the TIA. As you know, since the Schrems II decision of the European Court of Justice, it is necessary for controllers and processors, before they transfer any data, with reliance upon one of the appropriate safeguards mechanisms, to carry out a transfer impact assessment. And so Pauline will go in more detail on how do you exactly need to carry out such transfer impact assessment, and how do you have to document this? What are the different steps, in other words? So let's get started with the introduction. First of all, very clear, if we look at the GDPR, you look at the chapter 5 on international data transfers, it's clear that when you have a transfer of personal data, and this transfer of personal data is a transfer to countries outside the European Economic Area, and I will come back to that later, then there are certain risks and there are very strict rules that will apply to this transfer of personal data. And so when we speak about countries outside of the European Economic Area, we speak, of course, of third countries within the meaning of the GDPR. Now, the first question, of course, is what is exactly a data transfer? And it is a concept that is quite large, quite broad. It comprises, for example, the collection of data, the communication of data, copying of data, movement of personal data to be processed, and such copying, movement, communication, collection, and so on, from one organization to another organization. And I will come back on each of those points later in this introduction. Now, note already that there are several possibilities, and a transfer is not only where you really move data from one location to another location. There are different possibilities. First of all, think about data in transit. Data in transit means data that are just passing through. It's a temporary status. The data are passing through a channel, passing over a network, for example, and think, for example, about flux or about video streaming where data are passing through a network. That is data in transit. That's one possibility of transfer. Secondly, you have the transferring itself of data where you are going to move certain data from one location to another location. Think about when you send an email, the email goes from your computer to another computer together with the attachments, the information, the personal data which are included in the email or attached to the email. The same is true when you are copying files from one server to another server. You are moving data from one location to the other location. That is, of course, the most straightforward interpretation of what is a transfer. Think also about storage of data. So you may have data that are being transferred to another location merely for storage. When you use within your organization backup facilities or backup services from a third party, your data will be moved or will it be copied, for example, to other services and will remain there. And we speak then about data at rest. Think about archives also, think about backups, think about just servers where data are sitting and are being stored for you. And then the fourth possibility is where data is not only stored in the other location, but is also being processed. And this is something that happens more and more today, especially in the context of big data and in the context of artificial intelligence. Data are not just sent to another server, to another location, but at this other location, those data are being processed. For example, they are being analyzed by artificial intelligence systems to reach certain conclusions. They are being processed. They are being transformed. There are certain calculations being done on the data. So the concept of transferring data is very broad in and of itself. What can you think about as practical examples? Well, if you make use of IT service providers, think especially today about cloud service providers. Your data will be stored in the cloud in some location, and this location may indeed be in another country and may indeed also be in a third country, so a non-EEA country. When you make use of payment services, well, to carry out transactions worldwide, payment services will need to transfer certain personal data over their network, and this will include transferring to other countries. When you're, for example, using your Amex card in the US or in India, your data will travel along and there will be a transfer of personal data. When you make use of call centers, when you make use of certain marketing partners that make use of systems that are located outside of the EEA, you may fall into the category of a transfer and an international transfer of personal data. And of course, a very actual topic today, when you make use of platforms, social networks, think about Instagram, think about Facebook, LinkedIn, and so on, your data will also travel and they will be stored and processed in other locations. So in short, it's not only about controllers, it's also about processors that are being used by your company. One specific point of attention here is companies, either processors or controllers that you are using that may have an establishment within the EU, but with a parent company outside of the EEA. In that case, you may be facing a transfer of data depending on the specifics of the situation and whether or not, for example, the extra EEA parent company may have access or may not have access to your data. So pay specific attention to that scenario. What is not a transfer? Well, that has been clarified in the guidelines of the EDPB 05/2021. These are the guidelines that speak about the interface between the rules on territorial application of the GDPR on the one hand and the rules on international data transfer on the other hand. And what did the EDPB say? Well, they say, well, for a transfer to exist, there are in fact three criteria which must be satisfied cumulatively. So altogether, the first criterion is that there is a controller or a processor that is subject to the GDPR for a given processing, and that we call the importer, the exporter of personal data. So a controller or a processor subject to the GDPR that is transferring certain personal data to, and then we come to the second criterion, disclosure or making available of data to another controller or processor or joint controller. That's the second criterion. And then the third one is that the importing processor or controller is in a third country or is itself an international organization. And very important, and I will come back to that later, this is true irrespective of whether or not this importer, this data importer, processor or controller is itself already subject to the GDPR pursuant to its international or extraterritorial scope of application. So even if the data importer, which is established in a non-EEA country, is already subject to the GDPR because of the extraterritorial effect of the GDPR, even then the rules on international transfer of data will be applicable. Article 44 of GDPR also says that there is a transfer if data are being transmitted or disclosed and are destined to be undergoing processing or are intended for processing after the transfer. And the EDPB has clarified a number of things. First of all, they have clarified that when an employee reads his emails from his holiday destination, for example, the employee travels to India and is taking note of and consulting his emails from India, this will not be considered as a transfer within the meaning of the GDPR because there are no two controllers or processors on each end. The employee is acting on behalf of his company, and there is no company that is processor or controller that is sending over data to another processor or controller. And the same is true for a second situation where you have a data subject that is located within the EEA and that is inputting his or her data on a website, for example, a Singapore website to buy some clothes, for example. There, the data subject is itself willingly, voluntarily providing certain data to a non-EEA controller, but there is no transfer from one controller or processor to another controller or processor. So the EDPB is very clear on that. This does not constitute a transfer of personal data. Now, as I said, an important distinction is made within the GDPR between, on the one hand, transfers within the European Economic Area, and there the principle of free flow of information is valid, meaning that within the EEA, and that is the EU, the 27 countries of the EU, Iceland, Liechtenstein, and Norway, data may freely flow. There are no limitations, there are no restrictions. However, once you go to third countries and you transfer data to third countries, so non-EEA countries, there indeed the principle is that such data can only be transferred to third countries within or pursuant to very strict conditions, and those conditions will be explained by my colleague Olivia in the next part of the presentation. So let's maybe wrap up. When do we speak of a transfer of data to a third country? Three cumulative conditions. First of all, a controller or a processor that is subject to the GDPR for a given processing, that is the data exporter. Note here, very important, that this may not only be a controller or processor that is subject to the GDPR because the controller or processor is established within the European Union. It may also be a controller or processor which is not established within the European Union but is subject to the GDPR because of its extraterritorial scope of application. That's the first rule. Second rule or second criterion is there is a disclosure by transmission or making available otherwise of certain personal data that is subject to this processing, and it is a transmission or a disclosure to another controller or processor or joint controller, which is then called the data import. So you must really have on the two sides either a controller, a joint controller or processor, and also on the other side a controller, a joint controller or a processor. And then the third condition is that the importer, the data importer, is established either in a third country or is an international organization. And here again, what I stressed a few minutes ago, this is irrespective of whether this data importer is, yes or no, already subject to the GDPR because of extraterritorial effect of the GDPR. If the data exporter and the data importer are not different controllers or processors, then there is no transfer. I've given you a number of examples. And last but not least, remember that within a group of companies, different legal entities will likely be different controllers or processors. And so also within a group of companies, there may be international transfers of personal data. Let me give the word to Olivia Santantonia for the second part. But first, we have a poll question, and the poll question is, if the parent company of the EU importer is located outside of the EEA, is this then a transfer to a third country? And the answer is either yes or no.
Hi everyone. So now we will start with the second part of this of today's webinar, and we will now discuss the different legal mechanisms in case your organization company decide to transfer personal data outside of the EEA. As Bastien just explained, in principle and under the GDPR, transfer of personal data outside the EEA is a transfer considered at risk, and it's in principle forbidden except if you can rely on one of the different legal mechanisms that are provided by the GDPR. There are three kinds of legal mechanism, I would say. One, adequacy decision. Two, appropriate safeguard. And third, derogation exception. Which one you will decide to rely on will mainly depend on the third country where the transfer will occur, and more particularly depending on the level of protection granted to right and freedom of data subject in such country. First of all, we will speak about adequacy decision. Adequacy decision is not something new. Adequacy decision already existed under the directive, so a long time ago, I would say. And as you maybe know, adequacy decisions are decisions adopted by the European Commission. So what happened? The European Commission will decide to start an analysis of the legislation of a specific third country, and will examine not only the legislation but also the power of the different authorities and the power of the different agencies to check whether in such third country the level of protection to the right and freedom of the data subject is equivalent to the level that is granted in Europe. And so the EU will notably check whether the data subject will have enforceable rights, and if in such country there exist effective legal remedies. Then the Commission will make a first proposal that will be further analyzed by the European Data Protection Board. There will be then maybe amendments, and a decision will be taken by the EU Commission. And such decision is called an adequacy decision. The last one that had been taken concerned South Korea, and before it was UK and Japan. As you know, the list of third countries that can benefit from such adequacy decision is really limited, because so far there are only 14 countries that can say we have an adequacy decision. So as I said, there are UK, Japan, South Korea, but also Israel, Switzerland, Canada. But US, for instance, do no longer, as you know, benefit from such adequacy decision, because it has declared invalidated by the Schrems II decision. So in case of transfer to US or to China, to India, or to Russia, for instance, you cannot rely on an adequacy decision, and you will have to rely on another legal mechanism. What it's important to know too regarding the adequacy decision, it's not a decision that cannot be amended or withdrawn. No, there is, I would say, an ongoing analysis of the situation. And if, for instance, the legislation of a country or the behavior, the power of an agency will go too far and will have a negative impact on the right and freedom of data subject, the decision can be withdrawn, and you can no longer then rely on such adequacy decision to transfer data to that third country. But if you can rely on such adequacy decision, it's really for sure perfect, because then it's the most secure way to transfer personal data. We indeed consider that they can be transferred like they will be transferred within the EU, and you do not need any other safeguard to transfer such data. As I said, there are three different options for the legal mechanism. We have already discussed the adequacy decision, and we will now discuss about the appropriate safeguards mechanism. The appropriate safeguard mechanism there are 5 different, which are provided in the GDPR, and we will mainly discuss the 2 first, which are the BCR, binding corporate rules, and the SEC standard contractual clause. So first of all, the binding corporate rules. It's not a new mechanism neither. It already existed also under the directive. It was not often used because it's a mechanism that is quite burdensome, that takes quite a long time to be implemented. You have to go to the national supervisory authority and also have a positive decision from the European Data Protection Board. So it takes quite a long time to be put in place. And also, as mentioned in the name, it's only applicable within a group of company, an international group of company, so to apply for transfer within the group. And it does not apply for transfer outside the group. So it has a limited scope, and that's why usually a lot of companies have to use other appropriate safeguards to rely on for their international transfer of data. What you also need to know with the BCR, as I said, it's quite burdensome, but the advantage and the positive things with the BCR is that it's really a good exercise to check the compliance of the company and the group with data protection legislation. So it could be really helpful in that sense for a group of company. But since it's a contractual arrangement, like for the standard contractual clause that we will discuss in a few minutes, the Schrems II decision has also an impact on such mechanism, and it's not enough to have such mechanism in place to consider that the transfer will comply with the GDPR. No, you will also have to carry out transfer impact assessment, so some more administrative tasks, as it will be explained by Pauline later. Second, appropriate safeguard, so the standard contractual clause. The standard contractual clause are a standard set of contractual terms and obligation, which is really often used by a lot of companies, and which explain also that we discussed the question of the international data transfer so often too, because in the Schrems II decision, this relates to the validity of SCC and the additional measure that have to be put in place by organization. So the standard contractual clause, what is it? As I said, is a set of terms and conditions, a standard set that had been drafted and adopted by the European Commission. So this template cannot be modified by the parties. Since beginning of June last year, we have new set of standard contractual clause. We were waiting for them for more than 3 years. And there are two important dates. I would say no, only one, because it already is in the past. Since 27 September, you have to use this new template for your new agreements and arrangements in case of international data transfer. And for the old, we already used SCC before such a new template. You still have a transition period of nearly 1 year to enter into the new template, but it's already time, I would say, to at least make a checklist with all the contracts that are concerned, and to start, depending on the third country, to rework and enter into the new SCC. Regarding this SCC, you would maybe think, okay, there are a new template, but are there differences? What are these differences? There are a few main modifications for sure. The first one is that in the past there were only two sets of templates, and now we have four templates of SCC, and now we have also a template for transfer between processor to processor, and also from processor to controller. So that's the first thing that is new, and that's really important. In the past, we were really hoping to have such new sets, so it's good to have them now. What is also really good is that for the two last and the two new sets of standard contractual clause, all the mandatory requirements of Article 28 of the GDPR, so everything regarding data processing agreement, are already included in the SCC. So if you enter into SCC, you do not need beside to enter into a DPA. It's no longer needed, so it's something quite useful and helpful for organization. What else? There is also no docking clause, which enable easily multi-party configuration, and that enable that other source party entered into such international transfer agreement. So this facilitates this job too. It's clearly mentioned that if you rely on SCC, you have to conduct a transfer impact assessment. It's also required that data exporter and data importer can prove their accountability, and not only when they enter into the SCC, but also on an ongoing basis. And last thing which is new, there is an explicit reference to data subject rights, and it's mentioned that a copy or at least a summary of the international data transfer agreement has to be provided to the data subject if required. So these are the main changes with the new SCC template. As I said, there are other appropriate safeguard mechanism. There is a possibility to have ad hoc clause, so not to use the SCC, but to draft yourself your own clause, for instance. But then it will be subject to the approval of the European Data Protection Board. So it's not really recommended, and it's easier to use the SCC. First, there is the code of conduct. Code of conduct will be for sure in the future, especially for certain sector of activity, a really good appropriate safeguard mechanism. So far, there are already code of conduct, but not as a transfer tool. But you have to know that the European Data Protection Board is already working on such topic and published guidelines about this that were open to public consultation, and that will be adopted within a few months. And last one, always a little bit, I would say, together with the code of conduct are the certification mechanism. So far, there is no such certification mechanism in place, but maybe in the future. And the aim is also to have a binding and enforceable commitment for controller and processor in the source country. So now we have finished with the appropriate safeguard mechanism. And as I say, third option, that's the derogation. The derogation are exception and constitute, I would say, an additional threat to the right and freedom of data subject. So it's not the aim, it's not the objective for your organization to rely on such derogation every time you decide to transfer data to a third country. No. The idea is really, first you have to check if the third country can benefit from an adequacy decision, and if it's the case, that's perfect, you have understand, you have nothing more to do. If it's not the case, if there is no adequacy decision, so the second option is to rely on the appropriate safeguard. So you have to enter, for instance, into SCC. And if you cannot enter into this, because maybe based on the TIA, the SCC will not be valid, or at least their validity could be challenged, you can maybe rely on this derogation. But the best practice, it's only for transfer that are not repetitive. This cannot be a general approach, and this international transfer must be necessary. Article 49 of the GDPR lists the different derogation that can be invoked and relied on by your organization. The most used, I would say, is the explicit consent of the data subject. In such case, so as always, for consent, you need a specific consent form where you clearly explain the international transfer, the purpose, and you explain the risks that are linked with this international transfer of data. So you are sure that the consent will comply with all the requirements and will be valid. The ultimate exception is if the transfer is not repetitive, affect only a limited number of data subjects. In such a case, sometimes your company can rely on its legitimate interest. Last point before the question and before giving the floor to my colleague Pauline, and I would say again introduce our topic. What we have seen since no more than a year is that there are possible issues with the standard contractual clause and the other appropriate safeguards mechanism. Why? Because there was in July 2020 the Schrems II decision, which on one hand invalidated the privacy shield, so the adequacy decision for transfer to US due to the US surveillance legislation and the absence of legal effective remedies for data subject. But such decision on the other hand had also an impact on SCC, because it said, okay, SCC as such are valid, good thing, good point, but it's not enough to enter into this because it's a contractual arrangement, and depending on the country, maybe that after the right and freedom of the data subject will not be enough protected. So you have to examine the situation on a case-by-case basis on each third country, and based on this, decide whether or not you have to adopt additional measures to mitigate the risk for the right and freedom of the data subject. And that's the such exercise. It's the conduct of the TIA. And so it was really surprising for all organizations in once what I have to do. And hopefully the European Data Protection Board decided to help organization and adopted specific recommendation on the measure that can be adopted, and that will be further discussed now by my colleague Pauline. So just before a poll question, do you have to conduct a TIA in case a country of the exporter enjoy an adequacy decision? Yes, no, or it depends.
So now I will talk about the transfer impact assessment. So following the Schrems II decision of the European Court of Justice, it appeared that the appropriate safeguards set out by the GDPR were not sufficient to ensure a good level of protection. And so supplementary measures had to be taken. However, the GDPR or the court did not specify or define what these supplementary measures were. So the EDPB, the European Data Protection Board, issued guidelines on how to conduct such transfer impact assessments. And this is what I will be discussing now, the methodology that they propose. So with this TIA, we will do a regulatory analysis of the country of destination, because it cannot be that you transfer data outside of the EEA to circumvent the protection in the EEA. So the whole goal of this exercise is to guarantee an appropriate level of protection outside of the EEA, and so that protection must be essentially equivalent to the protection in the EU or the EEA. And this will happen through an active obligation of the controller or the processor exporting the data to take the measures to ensure this effectiveness of the protection. And these measures will be legal, technical, and organizational measures. Now, this analysis is also very important, because if the conclusion is that there is not a sufficient level of protection, then the transfer will have to be suspended. Before we start with the analysis proposed by the EDPB, it's important to remember that such a transfer is not only important for new transfers, such an assessment is not only important for new transfers, but also for existing transfers at the moment. And so it will be important to audit existing processors, because a transfer is not only you actively transferring data outside of the EEA, but it can also be processors that transfer data on your behalf. And so you will be responsible of that transfer by the processor. So it's not only your processor, but it can also be the processors of your processors, so sub-processors that will export data outside of the EEA. So it's very important to keep this in mind. And we will come back later with decisions of the CNIL and also of the Austrian Data Protection Authority regarding the use of Google Analytics. So you can be responsible of your use of Google's products and Google that exports data outside of the EEA. Now, before we go over to our first step of the roadmap, as I said before, doing this analysis is an obligation of the exporter, so it can be the processor, but it can also be the controller, of course. And very importantly, you must document the roadmap of or the analysis that you will do, because supervisory authorities can ask you to provide documentation on how and why you are transferring data outside of the EEA. So the first step is being aware of the transfers that you're doing outside of the EEA. So what data are you transferring? Who are you transferring it to? What country? How is this happening, etc. And of course, you don't have to start from scratch to do this analysis. You can use your record of processing activities, because if this is a full and complete document, then your transfers should already be documented in there. And also, according to Article 13 and 14 of the GDPR, you must be transparent towards data subjects regarding the transfer of their data outside of the EEA. So this first step normally should be built upon your record of processing activities and also your privacy policies. Now, of course, this first step has to happen before you transfer your data. And so this is the occasion as well for you to analyze if the data that you're willing to transfer are adequate, relevant, and limited, because of course, an important principle of the GDPR is data minimization. So this is the perfect time to assess this as well. Now, as I said before, it should be before, of course, before your transfer that you do this analysis, but we also urge you to do it for your existing transfers, of course. And then as a result of this first step, you should have a sort of map of destination, which includes all your transfers and all the relevant data or information regarding this transfer. And it's also important, of course, to take in mind, according to the definition that Bastien gave of a transfer, that you not only document your active sending of data outside of the EEA, but also processors or other parties that may have access to your data. So now that we are fully aware of the data that we are transferring outside of the EEA, we will look into the instrument, the legal instrument that we are using to transfer those data. And this is, I mean, the same as the question as Lydia just asked you, is the TIA necessary if you have an adequacy decision? You will have the answer here. So if you have an adequacy decision, then your analysis stops here. No further steps are necessary because the Commission already analyzed the legal situation of the third country and has decided that it's safe, that there is a good level of protection. And so the analysis stops here. Your TIA is ready if you have an adequacy decision. Of course, if one day your adequacy decision is withdrawn, like it happens in the US with the Privacy Shield, then you'll have to find another transfer instrument, and you might have to do this exercise of the TIA. So it's important to monitor your transfer instruments. Then secondly, if you have used an appropriate safeguard of Article 46, well, then you will have to do the rest of the analysis. Why? Because the Commission has decided, the court has decided that such appropriate safeguards do not guarantee by default a good level of protection in the third country. Then finally, if you're relying on a derogation, then the analysis stops here as well. You don't have to do the rest of the TIA. So this might seem an easy way out, but as Olivia said, a derogation must only be used exceptionally. It cannot be used regularly or as a rule. So now let's go to the third part of our analysis, which is the most burdensome part of the analysis, I think. And just to remember, again, this is only if you use an appropriate safeguard. So in this step, you will analyze if the appropriate safeguard that you chose provides sufficient protection for the transfer. And you will do this by assessing if the protection in the third country is essentially equivalent to the protection that is offered in the EEA. Now, as I said, this is quite a burdensome process, so we really urge you to ask your data importer to help you with this third part of the assessment, especially if you're not transferring data to the USA, but to a country of where you don't know the official language, then this will be very hard to do. So in this step, we will analyze the level of protection through analyzing the local legislation and also through analyzing the local practices. So first of all, the legislation. You will analyze the legislation that is applicable to your specific transfer. So contrary to an adequacy decision where the whole legal body will be analyzed, here you only need to take into account legislation that will have an impact on your transfer. And so in this, for this, you have to take into account, for example, the purpose of your transfer. So if you're transferring data for marketing purposes, other legislation will be applicable than if you transfer data, for example, for research purposes. Also, the sector of your import will be important. So is your importer active in the telecommunications sector, or for example, is your importer a law firm that benefits from client privilege? This will have a big impact as well. But also, for example, the format of your data. Is your data in the clear and can anyone read your data, or are they encrypted? This will have an impact as well. And then laws for which you have to be especially for which you must have attention are laws that oblige your importer to disclose data to public authorities, because public authorities are not held by standard contractual clauses, for example, because it's a contractual document and the public authority is a third party. And so this will have a big impact on the safeguards that Article 46 wants to bring, because Article 46 of the GDPR regarding the appropriate safeguards states that data can be transferred, and I read in the text, on condition that enforceable data subject rights and effective legal remedies for data subjects are available. So this is very important. Can public authorities ask your importer to have access to the data? Other elements that you can also look at is, for example, the rule of law in the third country, but also the local data protection laws, and also the other criteria contained in Article 45 of the GDPR, and these are the criteria that the Commission will use for an adequacy decision. Now, where do you get this information? Well, it should be publicly available information, and it should also be the practices that are enforced in the third country, and this works in two ways. On the one hand, you may have really good data protection laws in your third country, but in practice, maybe these are not respected by public authorities or the recipients or by your importer. Well, then the practice, of course, is very relevant. But on the other hand, maybe there are not sufficient data protection laws, but in practice, your importer has adopted supplementary measures already, or is having special caution for your data. Or maybe public authorities have another practice than what is stipulated in the law. So then this can be relevant. Now, of course, as I said, you have an obligation of accountability, and supervisory authorities may ask you to provide documentation regarding your TIA. And so in that light, information that you use for your TIA, or for this step at least, should be objective, relevant, reliable, verifiable, and publicly available, as I said before. Now, as I said, in this step, I think it has become obvious by what I just said, it's important to have help from your data importer. And later on, we will talk about some templates that you can use. And we have included the templates where that enables you to ask information to your data importer in the US. But we will come back on this later. So now that we have evaluated the risks, we can take supplementary measures to mitigate that risk. So if we came to the conclusion after our third step that there are risks and that the level of protection in the third country is not sufficient, well, then we can make that protection higher or better that protection by taking supplementary measures. And these measures come in three types according to the EDPB. First of all, you have the technical measures, you have the organizational measures, and you have the contractual measures that are on the next slide. And here the EDPB states that if there is a law, as I said before, that obliges an importer to disclose information to a public authority, well, then technical measures are necessary. You have to take technical measures because these are the only measures that can prevent a public authority from having access, because, as I stated before, the public authority is not part of your contract with the importer. Now, these measures, of course, have to be taken on a case-by-case basis based on your first three steps of the analysis. So this again shows that the first steps are very important because they will enable you to take appropriate supplementary measures. So we see here more concretely some examples of technical measures that you can take. So for example, you can encrypt your data. I will come back on this, but you can also pseudonymize your data. You can anonymize your data. You can mask your data, etc. There can also be organizational measures taken by the importer. For example, organizational measures, but also minimization of the data that the importer has. So if it doesn't have the data, then well, there is no risk. Or if the data is minimal, then there is less risk as well. Internal policies can also be taken, accountability, etc. Then you can also take contractual measures between you and the importer, where, for example, the importer has the obligation to inform you about legislation and practices. And so also when these legislations change or when the practices change, then you have all the information to take additional measures or to change the methods for transferring your data. But you can also oblige contractually your importer to implement technical means, for example. Transparency is also very important so that you as an exporter know what you're doing, etc. Now, of course, this is all very abstract, so we have included some more specific examples of such measures. Now, the first one is a theoretical example that has been given by the EDPB in its guidelines, and this is the use case where you, as an exporter, store data for example, in the US with a hosting provider. This could be Amazon Web Services or another service provider. And you can decide to encrypt your data here in EEA before sending it or putting it on the cloud in the US. And so this means that your hosting provider only has access to your encrypted data and cannot see the data in the clear. And so when the importer is obliged to disclose data to a public authority, well, then it can only pass on the encrypted data, and the data is not in the clear. And so this is a very, I wouldn't say easy, but an obvious way to protect your data. Now, of course, this encryption should happen with state-of-the-art algorithms, because if, for example, the US intelligence services ask access to your data, well, they will try to decrypt it, and they have very good methods and are very they are very far in their research regarding encryption. So it's important to use state-of-the-art encryption, and also state-of-the-art today is not the state-of-the-art in 2 years or even 2 months or in 10 years. So you really have to keep this up to date. And also, if new known vulnerabilities are discovered and published, well, then also you should change or mitigate the encryption that you use. And of course, a very important measure for this protection measure to work is that the encryption keys are kept with the exporter and that they are never accessible to the importer or to another party. So you must really keep this solely under your control as a data importer. Now, of course, finally, if the hosting provider needs to use the data for certain operations, well, then this scheme does not work. It needs the information in the clear, and so then you will have to find another solution. Another solution, for example, proposed by the EDPB is pseudonymizing data and sending only pseudonymized data or putting only pseudonymized data on your cloud. But there, of course, it's important to take into consideration that it's very easy to single out a data subject and that not many data points are necessary to be able to single out a person. So then we'll go to real life examples of decisions regarding supplementary measures. And first of all, we have a decision of the CNIL, which has not been published yet, but they have released a press release in which they say that the use of Google Analytics by a website provider was illegal because the supplementary measures that were taken by Google were not sufficient to ensure an adequate level of protection. And here the issue is that Google in the USA is considered as an electronic communications service provider. And so under those, the FISA or FISA regulation, this means that Google can be obliged to disclose data of their clients, and so also data of EU citizens that have to be disclosed to the intelligence services. And so there, the CNIL has suggested that maybe Google Analytics can be used, but only anonymous data that may be transferred to the US. Otherwise, the website provider has to cease the use of Google Analytics. So, of course, this is a very big impact on, I think, all websites, all people that provide websites or that have websites. The Austrian Data Protection Authority also issued a decision against a website provider that had health data on it that was using Google Analytics. And there again, there was no sufficient protection for this data in the US. And also the Data Protection Authority in Austria reminds you that even if you do not have cookies on your website, Google can use other techniques to identify the visitors of your website, such as, for example, fingerprinting. So this is, something to really take into account and to follow up on. Now, the CNIL is also, the French Data Protection Authority is also looking into the use of collaboration tools online of higher education institutions, which, of course, with the COVID pandemic, have gained in importance all over Europe. And so they have decided that these platforms do not provide a sufficient level of protection. And they're looking into supplementary measures, but at the moment they have not identified yet which ones would be appropriate. And so this shows that it's not an easy challenge if even a national data protection authority has issues with finding the adequate measures. And so at the moment, the CNIL recommends French higher education institutions to use other tools available to be able to collaborate online. Now that we have done our fourth step, we will go to the fifth step, which is not the most burdensome, but the most difficult one, I think, because based on the analysis that we just did, now you have to take a decision. Is there an appropriate level of protection in the third country with or without supplementary measures? If there is an appropriate level of protection, then you can go ahead and you can export your data. If there is not an appropriate level of protection, well, then you will have to suspend your transfer outside of the EEA. Voilà, just that as CNIL and also decided in 2 cases there as well, the transfer had to be suspended. Or maybe you have to find alternatives. Now, we remind you here at the end of our analysis that it's very important to document your transfer impact assessment, but because you have the accountability principle under the GDPR, and you have to be able to demonstrate that you respect the GDPR. So this documentation is very important. And also finally, it's important to remember that this TIA is not a one-time exercise. It's something that you have to do continuously. You have to monitor all the time or at regular intervals that you have to, this assessment has to be redone. So it may be also important to document at what intervals you are doing this again and again. And you have to monitor because, as I said before, for example, the encryption keys or the algorithm that you use is not up to date anymore, or maybe the Commission has withdrawn one of its adequacy decisions, etc. So doing this continuously is very important. Okay, now that we have finished our explanation of the analysis, I think it's very clear that this is a complicated exercise. And so to make it a bit easier on you, we have included some freely available templates that you can use. But you will see even with a template that it's still very complex. First of all, we have included a template of the IAPP, which is a template for cloud computing, and where you can do this TIA, but you will see that it's still quite complex. Then we have also included a template made by Rosenthal for also a TIA. And what is nice in this template is that the template has been filled in already, so you can see what has been filled in and maybe base your answers on the examples that are included in this template. Then thirdly, this is not a TIA template, but it is a form provided by NYOB, which can help you to analyze if the legislation in the US is applicable to your importer or not. And so this is a form that has to be filled in by your importer of data. And it's also included. It also includes questions regarding the measures that your importer has already implemented. So it's I think it can be very useful. And finally, we have included a web page of the CNIL. This is not a template, but it is a web page in French, which explains in an accessible way, I think, the TIA, and also gives you very concrete examples. So I think this can also be very useful. So now we will go to the Q&A. I'm looking at your questions at the moment. And I think when I see the questions, we have a lot of them, thank you, that it's maybe easier to answer them by email. But I think Bastian will come in right now. I will just get him to help me answer the question.
Okay, thank you very much for listening. We have now come to the Q&A. We've received a couple of questions. I will try to respond to a couple of them. Those who have not been responded to, we will come back to them by separate email to those who asked the question. Maybe a first question that was asked was this whole situation about the employee who is traveling and who is consulting his emails from a location outside of the EEA, where the EDPB says this is not a transfer. And the question there is, what about if an employee is accessing a Belgian database, but based in the United States and employed by an American affiliate? Would this also amount to a remote access? Indeed, a very good question. And in fact, it reminds us all that this exception as outlined by the EDPB is in fact very limited, because here the question asks, this is about an American person who is accessing a Belgian database, and the American is employed by an affiliate of the Belgian company. Here, of course, we don't have a remote access, which is exempted, so to speak, from the transfer requirements, because we are indeed in a situation with two controllers or controllers and processors at each end. You have at the one end the Belgian company, which has the Belgian databases. The database is running on European territory. But on the other hand, it's an American person who is employed by an affiliate of the Belgian company. So he is acting for another controller, or maybe this affiliate is a processor. We don't know. But in any event, he's acting for another legal person. So there we have at both sides of the ocean, so to speak, two different entities, each acting as either controller or processor, and we have to comply with the rules on international transfer of personal data. That was one question. I'm looking through the other questions. Yes, interestingly, I don't know whether we explained this during the presentation, but the question is, what exactly is a docking clause? And indeed, we said during our presentation that the new standard contractual clauses that have been updated and aligned with the GDPR, and we also mentioned that they now contain a docking clause. What is this exactly? It's in fact an optional clause that you can add to the standard contractual clauses, and which makes it possible for other parties to join this standard contractual clauses, so to extend the standard contractual clauses to, for example, a third party or a fourth party or a fifth party, which can be handy in some instances. So that about the docking clause. There was also a question about explicit consent and the use of standard contractual clauses, if I understand correctly. The question was, is an explicit consent of the data subject still needed in case of limited transferred data to a subcontractor outside of the EU, with standard clauses being used with the subcontractor? Well, it's either one or of both. Either you rely on the derogations, either you rely on other appropriate safeguard mechanisms. If I understand the question correctly here, there are standard contractual clauses entered into with the contractor or the subcontractor outside of the EEA, and indeed this will suffice. You don't need, in addition, to receive or to obtain the explicit consent of the data subject. And remember also that the derogations that are listed in the GDPR are really a last resort, as the EDPB has put it. It's when you don't find any other ground or any other mechanism to legitimize the transfer of personal data, then you can turn to the derogations. And this basically, as the EDPB says, only in exceptional cases. This also brings me to a related question from someone in the audience, which says, well, relating to the derogation, would the explicit free consent under Article 49(1)(a) provide a legal ground to transfer data to an inadequate jurisdiction where SCCs would not suffice? I think in principle this is in principle the case. There are no further conditions to these derogations. If you want to rely, and you can rely upon the explicit consent, you don't have to look at the other elements, and even you could, in theory, also rely upon consent where the SCCs would not work. So, for example, in certain cases where you transfer data to the US, where SCCs would not work, or would not be sufficient in and of itself, you could try to rely upon explicit consent. However, and this is then the question goes further, and the example that is given is a cookie banner with a separate consent for Google Analytics cookies and other US cookies. This is a very interesting question. I think there probably the but I'm here a bit looking into a crystal ball, but probably the EDPB, if they would have to argue this case or would have to analyze this case, they would probably again stress the fact that the derogations are really exceptions to the rule, and that in principle, certainly for systematic transfers of personal data, where there could be other mechanisms to put in place like SCCs or BCR and so on, in those cases that you could not rely on explicit consent. But the theoretically, the question is perfectly valid, and the answer is yes, indeed, you can use consent even to transfer data to countries to which you would not be able to transfer data on the basis of standard contractual clauses alone because of the legal system in that country. Maybe a last question for today. Yeah, interesting question also. Does an organization need to sign standard contractual clauses with a processor if this processor would transfer the personal data of the controller outside of the EEA because of a sub-processor? And there is some more information given. So you have a company A, which is located in European Union, which transfers certain data to a processor also in the European Economic Area. And this processor in the European Economic Area is going to transfer the data relying upon a subcontractor or a sub-processor outside of the EEA. If this processor signs standard contractual clauses, as we know, they are now possible between processors, so processor to processor, does the company, the data controller in Belgium, still need to sign standard contractual clauses with the first processor, which is located in Belgium? Well, I think the answer is no, because and this comes from the previous explanation that has been given by the WP29 on the previous version of the standard contractual clauses. They've always said, well, it needs to be a contract between a data exporter and a data importer. So you cannot have a contract between two companies who are based and established within the European Union or within the European Economic Area. So in principle, it should suffice to have the first processor sign the processor-to-processor contractual clauses with the sub-processor, which is located outside the EEA. I would add to that it is, of course, important that the controller in his contract with the first processor, which is still located in the EEA, that he includes clauses on transfer and that he keeps control, so that he knows when his data are being transferred outside the EEA, and that he has some measure of control on what kind of measures that the processor is taking to ensure compliance with the rules on transfer. And this includes, for example, that he may either agree or not agree on a transfer and on using this sub-processor outside the EEA. And secondly, that he may ask his processor within the EEA to provide him with, for example, a copy of the processor-to-processor standard contractual clauses that have been signed with the sub-processor outside of the EEA. I think we will finalize this webinar here. I think there are some further questions, but as I said, we will come back to them, to those questions which have not been answered by a separate email. I would all like to thank you for having attended this webinar. We at Lydian are at your disposal to discuss any aspects of international data transfers, help you drafting transfer impact assessments, or help you working on a process or a procedure within your company to ensure that any transfer of personal data is being done in compliance with GDPR. So thank you for attending and have a very nice afternoon, and see you at probably at one of our next webinars.